So our second panel is on pretrial matters, and the title is Pretrial Changes, Depositions, Discovery, and Service of Process, with a focus on how COVID has caused re-examination of various parts of the pretrial process. Our moderator is the wonderful Elizabeth Cabraser, who is known to many and certainly known to us here at the center. She is one of the country's leading lawyers, founding partner of the Lieff Cabraser firm, and well known in the plaintiff's bar for pursuing some of the largest and most innovative cases in recent history. She is a graduate of the University of California, Berkeley School of Law. And I could go on and on about the many things that she has done in her career and prizes she has won, but we would be here all day. So why don't I turn things over to you?
Thank you, and good afternoon. And what I'm hoping is not to hear the dreaded "you're on mute." So, assuming that I'm not, what I'd like to do is introduce our spectacular array of panelists for the second panel, the pretrial changes panel. We're very, very fortunate to have the esteemed Evan Chesler. As I'm sure all of you know, he is the chairman of the Cravath firm, where he has been since 1976, as a partner since 1982, and is head of litigation for Cravath from 1996 to the present. He is currently the chairman of the firm, and he has been honored by everyone and has won everything deservedly and placed on recurring lists of top litigators. He's an NYU Law School alum, Order of the Coif, of course, and started his legal career clerking for Judge Wyatt in the Southern District of New York. Our second panelist is Ndiaye, who is the supervising attorney of the Decarceration Project at the Legal Aid Society. I love the name of that project, and as you would guess, it is a litigation and policy initiative dedicated to ending pretrial detention of low-income New Yorkers, and of course, addressing and eradicating the criminal justice system's disproportionate impact on communities of color. Prior to rejoining Legal Aid, Marie was the senior policy manager at the Cattell Center for Health, Equity, and Justice. She's a Harvard Law grad. We are also very fortunate to have the Honorable Melissa Crane with us from the New York County Supreme Court. She has been a New York State Court judge since 2013. She served on the New York County Criminal Court prior to joining the Supreme Court. She previously served as court attorney for Judge Moskowitz and is an experienced litigator as well, having worked at Hughes, Hubbard & Reed and Kasowitz, Benson, Torres, and Friedman. She's a graduate of Cornell. We've asked our panelists to focus on pretrial proceedings. We know that the COVID-19 crisis has had a tremendous impact, an eradicating impact, if you will, on the ability of most courts to hold criminal trials and civil trials, at least as they have been. As those of us who are litigators have seen our 2020 and many of our 2021 trial dates evaporate. So of necessity, we are forced to focus on the work that the courts can do and that we can do in the courts. And that is not exclusively, but predominantly these days, keeping the pretrial wheels turning, preparing for trials, keeping the process of discovery, depositions, pretrial hearings, pretrial conferences moving along. And I thought we'd start with some observations from Marie. She really works at the intersection of criminal and civil law and justice, working on habeas cases and dealing directly with those who have never had complete access or the complete ability to work for their own justice in our court system. COVID hasn't helped. But Marie, how are you coping?
Thank you, and thank you for that introduction. How am I coping? It's a bit of a loaded question. So I can probably just tell you what's happening in court or not happening for us. But I think what COVID has done in the public defense context, and I probably all representation of indigent or no income people, it has exacerbated most of the problems I think that have already been the reason why people have public defenders in the first place, and it has not made any of those issues much better. So I don't even know where you would like me to start, but at the intersection of the criminal and the civil is our habeas writs that we filed at the beginning of COVID, because one of the things that we know from healthcare and correctional health professionals and epidemiologists is that, COVID really spreads and takes a toll in congregate setting. And that's why we saw the large outbreaks that we saw in nursing home facilities across the state, across the country, and the same with jails and prisons. And so our first task was really, how do we get the most people out of Rikers Island and also our upstate work, but I'm going to talk more about our city habeas work. So we probably learned of the COVID virus, March 15th or 16th. And by March 20th, I was in court with my colleagues and we were arguing our first mass habeas writ in criminal court, a Supreme Court, but it was criminal, even though habeas are civil proceedings. In New York, they are signed by a civil judge and then sent to the criminal Supreme Court to hear and to decide, arguing release for about 100 people. And we continued that process for a couple of months, and we filed numerous mass writs, and we won some of them even, which was great, in addition to a lot of individual writs of habeas corpus for individuals who are 50 years old and older, or who suffered some medical vulnerability that made their exposure to COVID deadly. And so we got hundreds of people out throughout that process because, courts were running, the criminal court doesn't stop, at least.
Thank you. How are you seeing the ability, the ongoing ability of the courts that you are dealing with to handle the docket, the caseload that you are responsible with? Are things slowing down, staying about the same? What is the impact of COVID on the efficiency of what you're able to accomplish for your clients?
It has its positives and its negatives. The negative is that, a lot of our attorneys are absorbing clients, again, because, arrests don't stop and arraignments doesn't stop. And so you're picking up cases of people you're representing, but court is not going about in the same process. So you're not also getting rid of cases in the way you would, right? So if somebody's waiting on a trial because they're not going to take a plea or whatever, and the case hasn't or can't be dismissed because speedy trial rights were suspended, then that person is still waiting. So that's a case that you're still holding on to. And, if people's court dates are adjourned 6 or 8 months, if they're out at liberty, then that's 6 or 8 months where you have this case and you can't resolve it, or you're not resolving it, or it's not being put on the calendar to be resolved because it's not a priority because this person is not incarcerated. So it's adding to caseloads because you're absorbing more cases and you can't resolve cases in the normal way that you would, which is kind of how it generally works. But the positives are, I think, coming out of this, and some people were talking about this on the last panel, is that we are going to see less frivolous, I would say, court dates for people in the criminal process. You could be charged with a misdemeanor and have to come to court 20 times before that misdemeanor is resolved or before it's dismissed. And I think this time is showing people that we don't really need people coming into court, every 2 months for nothing to happen on their case, just so they could be sent on their way. It's very inefficient and costly, I think, for the system, but also for our clients, who are the ones who have to, halt their lives for a whole day to come to court to do nothing, basically. So I think coming out of it, we'll see some good changes to the system, but currently it's definitely not ideal.
Thank you. And I'll come back to you later because I think we're all really interested in some of your prescriptions for how to take the benefits, the pros, the inadvertent upsides of COVID's impact on the court forward, just as the last panel did. But I think let's now do a study in contrasts. And I'm going to turn to Evan Chesler, who is a preeminent litigator in the civil litigation, complex litigation field. And I'm going to go out on a limb and call that, not disparagingly necessarily, the litigation of privilege. Evan, you're used to getting the attention of the courts. Your cases are important cases. They may be bet the company cases for your corporate clients. They're likely mostly in the federal courts. You've got a judge assigned to your case from front to back. How has COVID impacted the pretrial aspects of conducting that complex litigation from the very beginning service of process through the main slog of discovery, depositions, documents, and witnesses?
Thank you, Liz, for that question. So I want to sort of sort the experience into 3 categories: positive, neutral, and negative. On the positive side, I think the main benefit has been a recognition that the technology actually can facilitate and speed up the process. As I'm sure is the case for you, since you and I have met in courtrooms around the country, and you're based in California and I'm based in New York, we both in the pre-COVID days spent a lot of time traveling to courts for things other than actual trials, for relatively routine hearings. And on the positive front, I think what's happened is lawyers and courts have come to recognize that much of that travel is unnecessary. The technology provides a basis to conduct routine status conferences, court conferences remotely. And that saves a lot of wear and tear on everyone and saves a lot of expense for clients. And I've been told by judges that they're able to move through a docket of status conferences and arguments, for example, on discovery matters more quickly by doing it remotely than they were able to in the pre-COVID world, because there's less movement around. You're not waiting to clear your courtroom. In the cases that I deal with, often there are dozens of lawyers in the room, and they're chatting and they're collecting their things and moving on. So the positive side, I think, is the technology has become a pretty well recognized substitute for a lot of the business of the courts on the civil side, the more routine matter. In the neutral category, I think the actual conducting of conferences before the courts non-evidentiary proceedings. And depositions, in many respects, are more or less, I think, the same. That is to say, you're not physically gathering in one spot. There isn't any particular advantage to doing it remotely, but in many respects, there are not particular disadvantages. I can sit as I am now looking at you and the other members of the panel, and I can say something and you can respond in real time. And that's analogous to my asking a question of a witness at a deposition and the witness answering me. And that has been relatively seamless in my experience. And that's been true also of routine conferences before the court. So I think that one falls into the neutral, or though both of those fall into the neutral category. On the negative side, I'd point to several things. First, there are disadvantages to some aspects of depositions using technology. I have found that witnesses are, for example, at home. They may or may not have the kind of bandwidth that is appropriate, for example, to download voluminous documents. And many of the cases I deal with involve document-intensive evidence and sometimes very long documents, presentations to boards of directors and annual reports and that sort of thing. And you can sit there waiting for Godot as the witness waits for a document to be downloaded onto her system at home so that she can see page 72 of a 100-page document and be responsive to your questions. There's also just the logistics of looking at documents and flipping through documents in the course of the give and take of deposition questioning that I've found to be at times more awkward and more difficult than it would be if we were sitting across a conference table at a deposition. There's also the problem of the lawyer who's defending the deposition not being often in the same place as the witness whose deposition she's defending. And sometimes, just because of the technology, it's very hard for the lawyer to interpose a timely objection and get the objection in between the question and the answer, or to get the witness to stop talking. I had one instance where the witness was about to answer a question which might have involved privileged information, and the lawyer on the other side was trying to get the witness to stop so that he could interpose an instruction not to answer. And we had to kind of re-roll the tape, so to speak. And, you know, I said, I'm not going to assert that the answer that was begun is a waiver, because I could see the lawyer trying to interrupt his witness. So I put that in the negative category. Lastly, and then I'll stop, is the fact that trials are being put off. I have jury trials that I'm supposed to be doing, which of course are not taking place. And I've got bench trials, one in particular, which has been rescheduled 3 separate times because of whatever, for one reason or another, doing it remotely was not acceptable to one side or the other, or frankly to the court. And so that trial's been delayed what will now be well over a year at 3 separate junctures. So in the pretrial category, I would put the delaying of trials in as a negative, because we are at the end of the day in the business of trying cases, and putting them off is not a good thing.
Thank you so much. And a little later in the panel, I want to come back to you and get into the nitty gritty of depo protocols, issues and problems with working those out, and dealing with the remote witness issue, which a number of attorneys have expressed unease about. But I want to go to Judge Crane, who runs a very busy commercial litigation docket in New York, and ask you, Judge Crane, to take us through your day and your docket and how you are dealing with the impact of COVID on your operations.
Sure. So most of my cases, 99% of them, are non-commercial division commercial cases. So that's commercial cases below 500,000 in New York County. And these, so it's less money. And these cases really lend themselves to remote proceedings. So we are as busy as we've ever been. In any given day, I have now, my court attorney is actually out, so she comes back January 20th. So I have been handling the whole part myself. I have 800 cases. I have a very good backup from someone in the law department on the conferences, but otherwise it's mostly me. And so we are doing conferences, we're doing motions, we're doing bench trials. Since COVID hit and I had the go-ahead to do remote proceedings, I've done 8 hearings and or bench trials. So it's really super busy. And I think if it hadn't been for technology, I don't know what would have happened, because the cases would have just piled up and it would have been unmanageable. But it's going really well. As I said, these cases, the lawyers seem to really like the savings of not having to commute in. You know, when we were in person, the way I schedule my part, because of the volume, and remember state court, it's huge volumes. I would do 2 motions in the morning, 2 in the afternoon, squeeze a trial in between, and then we'd have conferences all going on at the same time. So I'd have a huge collection of people in the audience. My clerk would be talking to me. It was crazy. I prefer it this way because I'm able to focus, like I'm focusing now talking to you all, on the issue at hand, and I'm not being constantly interrupted. So it's actually been better in that respect. I think where we may have, where I have some concerns are, you know, with the digital divide, which I think Marie can talk about maybe later, but in terms of public access, that's something I've been concerned about. And if there's a press case, there has to be some sort of pre-arrangement. We've streamed, I've had press cases and we can arrange for streaming, but it's not like the press and the public can walk off the street and come into the courtroom. So I think there's, but we have arranged for streaming. It just requires somebody to ask and request it.
Are you seeing that you're able to accomplish as much in terms of moving your docket now as you were pre-COVID?
Absolutely, absolutely. My numbers are way up since we've been back, and which was at the, I mean, I've been doing remote arguments since May, and I do about 3 to 5 motions a day, and squeeze again, like I did before, squeeze the trial in between. So yeah, we're getting a lot done here. I've been very pleased with how that's been going, and the buy-in from the bar has been great.
Mm-hmm. And is there any difference in how cases are initiated in your court during COVID in terms of filing, service of process, appearance of parties through counsel? How is that working?
You know, that's a really important question. So we have, most of my cases the clients are represented, and we've had, you know, that's most of what occurs, but we have had the here and there non-e-filed case, and to have a paper case during COVID is a nightmare. And so some people who are maybe self-represented and don't have as good access to technology are really at a disadvantage, and that's unfair to them. I've been struggling with that and what to do.
Mm-hmm. Have you or your fellow judges come up with any ideas or proposals or initiatives in that regard, or are you just you know, keeping things moving at the front end as best you can?
Well, I'm trying to keep things moving. With respect to the paper cases, I've had to take them on submission without oral argument. That was what I determined was the most fair. If I see that something is going to need oral argument, I will make arrangements. So far that hasn't happened, but I've had people participate by phone. So I would most people have access to a phone or they can borrow a phone. And I would make do that way. I'd have them call in to my number here, and then the court reporter could write everything down from the phone.
Okay. And, you know, one more item on statistics, or at least impressionistically, are filings and case initiations slowing under COVID with respect to your department, staying the same, increasing? Or is it too soon to tell?
You know, they got rid of 46, or they didn't certificate 46 judges, 5 of whom were in New York County, I believe, 5 or 6. And that really affects the independent assignment system parts, which is like what I have. They were all from that group, and those cases are going to have to get absorbed somehow. So I would think my docket will go way up.
Okay.
But I would have to get back to you and research whether filings are down or not.
Yeah, this is something that I think people across the country are trying to get a handle on, and it's hard because there's a lag in statistics, and
Right.
although it seems like forever, we've been less than a year under COVID in terms of criminal filings and civil filings is the business that the courts are going to have to handle, increasing, decreasing, staying the same, and I don't have a good perspective on that. I've noticed that in the little area of law that I practice a lot in, civil multi-district litigation, the number of proposed multi-district cases or MDLs that the judicial panel has to consider have been going down pretty steadily. Don't know whether that's COVID or other criteria. Let me move back to Evan for a second and drill down a bit on the business of depositions and other pretrial discovery. You mentioned a concern about witnesses. First of all, have you noticed in your cases lawyers resisting or pushing back on the conduct of depositions given logistical difficulties or representational concerns? In other words, how do you keep the business of depositions going in a case, given the lawyer's concerns about, I can't be with my client to prepare, I can't be in the same room with my client for the deposition, there are logistical concerns with documents. Have you seen the process slow down, and how have you address this in your dealings with your co-counsel, your opposing counsel, and the courts?
So I think the curve was sort of like this. In March and April and even May, there was clearly a slowdown in depositions. People were trying to deal with getting familiar with the platforms, Zoom and the other platforms. They were dealing with the logistics of being in a law firm where they're not physically together. And so I think there was a dramatic slide downward in volume in the first 8 or 10 weeks or so of the pandemic. My experience is since May or so, the level of activity of depositions in particular has come back. I have not, in the last 4 or 5 months, maybe 6 months, I've not seen a material impact on the deposition programs in the various cases in which I'm involved. They're pretty much now going forward, with the normal kind of scheduling issues that have always existed. A witness is not available on a particular day, or a counsel on one side or the other has another commitment. But putting those to the side, I think we're pretty much back at the depositions to a schedule that is comparable to what I saw in the time before COVID. There's still issues. People are still, grappling with the reality of doing depositions in a COVID world. Let me give you one example, which I found to be the most impactful. Very often, the witness. Let's take the side of defending the deposition. So you're the lawyer who's going to defend the witness at her deposition. Very often the witness is not someone whom you know very well. you know the general counsel of the company, you know the senior executives perhaps of the company with whom you deal. But now you're dealing with a fact witness who may be, 5 layers down in the organization, who knows about a particular subject matter, and she's being deposed about that subject matter. And you may not have met her before the time that you need to prepare her for the deposition. Just the reality of how the interpersonal relationship in that process develops when you're sitting together in a room, when you can take a 5-minute break and go get a cup of coffee down the hall and have an informal conversation about things other than, the subject matter at hand. Just the mechanisms by which people develop a kind of congenial, friendly relationship, and you win the confidence of another person in that process, and that facilitates the process of preparing her for the deposition, which may be a process with which she is totally unfamiliar. And the whole idea of sitting under oath in front of a screen and being asked questions and about things that may have happened 5 years before, and struggling to remember the detail of who was in a meeting and what A said to B, that can be an intimidating experience for a witness. And winning the witness's comfort level and confidence in the preparation process can lead to a much more workable and frankly successful deposition for everybody. My view of a successful deposition is one in which the witness is able to tell you what she knows about a subject, and her recollection is maximized and her comfort level with the process is at a satisfactory level. So it goes in an orderly and an appropriate way. I'm finding that process is somewhat inhibited by the physical remoteness during the preparation process, and the witness's level of comfort with an unfamiliar procedure isn't necessarily as high as it would be if you'd been able to spend that same amount of time together in the same room, interacting in the old-fashioned way. And so I think that's the most tangible negative impact that I've found in terms of the deposition process.
Marie, you have to deal with your clients and gain the trust of your clients and their cooperation and their respect. And you also have to deal with obtaining the discovery and information that you need to represent them. How has COVID impacted your ability to do this, and what have your strategies been to overcome those difficulties?
Yeah, so I think for us in the criminal field, the problems really started at the very beginning because we had to do remote arraignments, right? So what Evan is just describing is a deposition where, you're representing someone, they're going to answer questions. For us, we're going to meet somebody for the first time, probably after maybe the worst day of their lives. Maybe they had a bad interaction with the police beforehand, whatever the case may be. But in normal times, we'd be meeting this person in person. I mean, there would be unfortunately a gates and cage in front of you, but at least you get to speak to them. They get to see you, you get to see them, and you can talk to them for as long as you need before going out and seeing a judge. Now since March, we've been doing all of that remotely. So this person who's getting arrested is meeting their lawyer for the first time on a computer. Like this, how we're speaking. And then you have to go through all of the sensitive information about their case, about their background. And then when they're in front of a judge, it's also like this, right? So there's a judge who's at home or in a courtroom, but remote, and they're looking at our client remotely, and we're all, basically one big Zoom. And it was hard enough gaining, someone's trust and respect in person in our field, but it's even harder to do remotely. And that issue doesn't stop once they're out, if they're released after arraignment, because they can't come to your office and talk about their case, right? We're not in our offices. There might be an access to technology problem, which we will get to, but it's even worse if they're incarcerated, because then they're incarcerated, and the only way you can speak to them is through video conferencing that has to be set up with DOC. And we've had numerous issues with that. You know, you want to speak to your client and you can't get a space for 2 weeks because this is how we are all speaking to our clients, right? And so you can't talk to them about the case. You might not be able to talk to them very long before deciding whether they should testify in a grand jury, when we had grand juries for a brief period of time. And so it's been, I think everything about that aspect of COVID has made this worse. Like the inability to have access to our clients is really detrimental in this. The other part is that, you know, arraignments used to be public forums, right? You can walk off the street and come watch an arraignment, which some people do. I've never quite understood that, but people do that. They take tours, but family members, it's important that people's families could come because that's part of the arraignment process, right? I want to tell, you know, Judge Crane that my client's mom and dad and brother and sister are in the audience and he has a reason to come back to court and they're going to support him and they're going to help him. And you can't do that in the same way that you used to because of COVID. So that part of the technological aspects is, it's all negative. I don't think there's really any positives there because it really makes communicating with our clients difficult. With respect to having access to then other parts of the pretrial stuff like discovery, unluckily or unfortunately for us, when COVID started, Governor Cuomo released some executive decisions that suspended most of the due process aspects that you're talking about. So discovery statute was suspended. So prosecutors did not have to hand over discovery. Our grand jury practice was suspended. So people charged with felonies who were incarcerated did not have to be indicted within the statutorily allowed amount of time. And our speedy trial statute was suspended. So a case like a misdemeanor was supposed to take 90 days, which generally took a year anyway. It's probably going to take 2 or 3 years now because we haven't had a speedy trial statute in effect in months. Sorry, I thought you were going to say something.
No, go ahead.
Yeah, so it's been all of those things together have made the criminal process, I think, just really worse because it's taking, it was already a process that was bogged down and, you know, took a long time. Cases didn't move, nothing was resolved. And now it's that way, but there's no due process. There's no discovery, there's no trials, there's no hearings. So it's not great.
All right. Well, we'll come back to you perhaps. I'm hoping for some positive prescriptions when we have the necessary discussion that we have about the digital divide. Judge Crane, the lawyers mourn the loss of personal contact with clients and witnesses and are missing the ability for that personal connection to build trust and communication. You know, we rely on our clients, they rely on us. Your vantage point from the bench is a little different. How are you dealing with the fact that for you, in what is now a virtual courtroom, a remote courtroom, you can't look us lawyers in the eye and strike terror into our hearts and incentivize good behavior. And you also don't have the in-person contact with the parties or witnesses either.
Well, I will say that in terms of hearings and bench trials, I actually think the virtual proceeding is better if you are the fact finder. And here's why. When I'm in the courtroom, I have the witnesses to my left, and I've got my clerk to my right. I've got my court attorney coming in and out with questions. I've got a whole full audience that's you know, talking to each other, perhaps. I've got people coming in and out. a madhouse because it's state court and I have 800 cases. We've got orders to show cause coming in and out. It's nuts. This way, I can, the bench trial's going on and I press spotlight on Teams and the witness's face is literally blown up on my screen and I am catching things I never would have seen otherwise. So it's just, facial expressions, people looking down when they may not be as secure in what they're saying, things like that. Now, for a commercial case, does it really matter? No, because the documents are going to tell the story most of the time. But it's been very interesting because we were all talking about, oh, how do you assess credibility over the screens? And people were really concerned about it. And I just don't think it's a problem. I think it's actually better this way. Really. I don't know if that answers your question.
More for us as attorneys to worry about, I guess. You used to only
I do miss seeing the
distance.
I do miss seeing the attorneys. It's a little lonely. I'm actually in the office and I do miss seeing the attorneys, and having, it's harder to have, ask people how they are but aside from that, I think it's more efficient and I'm missing less in the witness because I don't look directly at them when I'm on the bench.
On Zoom, we literally cannot run, nor can we hide from you, Your Honor. So, and that's something that I hadn't thought about just in terms of, I notice now that when I am in a remote hearing or a conference, I am seeing the judge up close and personal more than I ever did before, not across the vast expanse of a courtroom. And I have considered that to be an advantage. And of course, it works both ways. I'm told that it's time to give the code. So I'm going to give the code. It is CCJ, CC21 for this panel. Again, CCJ, CC21. And let me swing back to Evan in terms of the daily life of the civil litigator, which is just one hearing and conference and possibly pretrial or appellate oral argument after another. I'm going to include the appellate experience here as well. What are the pros and cons for you of preparing for and giving, attending, preparing for, giving those oral arguments, conferences, which do you, and again, you do the positive, neutral, and negative. So which are better remotely? What's neutral? And what, if any, would you prefer or require that we go back to, assuming we can get back to a new normal or some hybrid of the old one with in-person courtroom proceedings?
First, one of the major differences in my day, which, as I said before, I think is probably a positive, is I'm not traveling anywhere. In the pre-COVID days, I traveled about 150,000 miles a year in and year out. The bad news is I no longer have the largest collection of airline points to give to my children that I had before, so that they could go on vacations without paying for airline tickets. On the other hand, they're not going on vacation, so I guess it's kind of a wash. But I do not miss spending so much of my life in airports, waiting to get on planes, and all of the hassle of just being a travel warrior is not something that I miss. And I've done several, in fact, in the last 2 months or so, I've done 2 federal appellate arguments, one in the 11th Circuit and one in the 2nd Circuit. And those actually, the arguments themselves, I think were probably positive. I put it in the positive category in the sense that Justice Crane was talking about. There was more of a kind of a face-to-face interaction with the judges during the argument. They weren't standing, yards and yards away up on a bench, and I was down at a podium quite far away. We were actually having more of a conversation, I suppose, than is often the case in an appellate argument. And that was true of both arguments in two different federal appellate courts. So that, I think, was probably a positive. In terms of negative, the biggest negative is a function of not being together in groups of people. And that has a number of manifestations, at least from my vantage point. I try a lot of cases. Every year I try cases. Now they're big cases, they go on for a long time. So it's not like the caseload that Justice Crane sees in her court, where those lawyers who are trying cases may try a dozen in a year. If they're, smaller cases involving less money, I may try, 3 in a year or 2 or even 1, but they go on for weeks and weeks. And there's a lot of preparation running up to the trials themselves. And that process, for me and my colleagues at my firm with whom I work, is a very, very important part of our lives. It is part of what I view as the obligation that I have and my partners have to teach our associates how to be trial lawyers. I view that as one of the, other than my duty to my clients, it's probably the most important responsibility I have as a lawyer, is to train the young lawyers who work with us. That is much harder to do remotely, just because of there's more of a formality of having to schedule a Zoom conference and see people as a group, as opposed to getting up from my desk and walking, a couple of 100 feet down the hallway and walking into an associate's office and spending 20 minutes talking about some problem that's arisen and what needs to be done, which is part of that educational process. And a corollary to that is the team building experience of trying a case together. If a dozen people go off to city X and spend a month in the week or so running up to a trial, and in the several weeks of the trial, and perhaps in the days immediately following the trial, if there's some post-trial motion practice going on, the experience of spending that month together in the long hours, 7 days a week, the intense preparation that goes on, the daily, reacting to what happened in court that day and preparing for what's going to happen in court the next day. There is an important both educational and human bonding experience that takes place in that process that often forms friendships that last for many, many years thereafter. And you have this common experience that you share with other people, and that's missing now. That's not in my day, in my experience. Excuse me. And I really miss that. And I think the people with whom I work miss it because they're losing that experience as well. So the technology can compensate for part of that, but it cannot compensate for all of that. And in terms of the trial, for jury trials, certainly, and as I said before, for some bench trials, it's not compensating at all because those trials aren't happening. They're being kicked down the road to some future date. The last point I'd make is it also changes the relationship I have with my adversaries. Seeing them in court is part of the building whatever the relationship is, good, bad, indifferent kind of relationship that you form with your adversaries. And again, now it's entirely remote. And to the extent that actually having a sidebar kind of informal face-to-face conversation in the courtroom right after a court conference, right before a court conference, actually builds collegiality, enhances the professionalism of the conduct, leads to a better outcome for everyone because the lawyers are getting along better, which I think is always better for the clients on both sides. That's also missing. That element of human interaction just isn't available today. So as is true of virtually everything in life that happens to us, it's a mixed bag. There are good things and bad things. I think being a trial lawyer in the age of COVID is the same. It has its positives and it has its negatives.
Thank you. Yes, litigation is a cultural experience and a very personal one. Converting to digital litigation, I think is at the least for those of us who are used to the interaction, the collegiality, the discussions in the hall, team building, relationship building, including with opposing counsel. There's a definite challenge in terms of how to undertake that and to make that work remotely. We have some very interesting questions, which we will get to in a few moments to close the panel. But in the meantime, I wanted to get back to something that was raised in the preceding panel and doubtless will be raised in every panel. And that's the very obvious question of the digital divide and whether and how we can actually use the COVID experience as an opportunity, not only to sustain, but to promote and increase access to justice. People have talked about the obvious cost and time savings. Sam Zakharoff mentions the savings of wear and tear when one doesn't have to travel across the country for a very short argument or hearing. Evan mentioned the downside of not being able to travel and to be in one place together in one time to prepare for and conduct a trial. We're hearing of people that may be completely left out of the new justice process because they don't have access to the technology. We've also been reminded that those same folks may not have had access to physical courthouses because of the need to take time from work to travel, and just because of the intimidation factor of what can be a very scary place. The courtroom is still an intimidating and scary place for me, although I miss it. So let's, Marie, where do you see, what would you keep, what would you jettison, and what would you change in order to use the situation we've been placed in as an opportunity to improve access to justice for your clients? And how do you handle the digital divide?
Right. Well, first, I really have to second what Evan said about missing the interaction with your colleagues in the office. It probably happened a little different at Legal Aid. We usually just hear people walking down the hallway yelling. There's usually curse words involved. I really do miss that myself, the ranting and raving. So that's one. But yeah, I think for us, our clients have always been at a disadvantage when it comes to court proceedings. And that's whether they're in person or now remotely, right? So before in person, we'd had clients who would miss court because they couldn't, afford the MetroCard fare or, the childcare fare or, get off of work. So they were already disadvantaged there. And imagine someone who was already suffering from, employment instability, housing instability, whatever the case may be. And now in order to participate in the process, they have to have a phone, but it can't be any phone, right? It has to be a phone that's good enough that it can take this technology, whether it's a Zoom or a Teams or WebEx, not to mention the fact that those things keep changing also. Then they have to be able to operate it, right? So you have to have enough, at least wherewithal, to know how to operate the Zoom and the mute and the unmute. But there's also costs involved when it comes to paying a data plan, or is it over Wi-Fi? You have to pay for Wi-Fi. And, there was at some point where you could go to the McDonald's or the Starbucks. It's not ideal when you're talking, especially I think for a criminal case, because you are discussing very sensitive information and you probably don't want to be doing that in the middle of a public space. But it's not really an option because these are not places that are open for the public to come and sit around and lounge to have a, a court date or an appearance that may last, 2 minutes or 20 minutes. So, and what we've done, legal aid has gotten been granted some money. So we can provide phones to some clients. I know the supervised release programs in New York City, which run our pretrial release if somebody's under court supervision. And if they're giving someone to supervise who doesn't have a phone, they've been giving people phones. But that part of it, it is costly no matter who's doing it, whether you're paying your own phone and Wi-Fi plan, or if it's supervised release, or if it's, the Legal Aid Society, it's costly, and it's a cost at different places also. So if we lived in a world where everyone had access to the phone, the data plan, the Wi-Fi, I'd love to keep this aspect of it, or at least for clients who have that capability. I do think one of the positives is that we are going to really reduce unnecessary court appearances in the future. So you're not showing up 20 times for your misdemeanor case to be resolved. If it's on for motions, I would literally get in front of the judge, I would hand up papers or I filed them before, and then we would all leave. Those things can be done without the client at all. Or, if they can call in and say, yes, I heard the motions were filed. Yes, I know this is my next court date. I think that's one of the things, the main positives that we should keep.
Great. Well, Justice Crane, if you could issue an order today decreeing which of the COVID improvisations of your court will be kept, which would be dumped, and which would be, and what you would do to change your operations going forward in what we're hoping is the new normal, what would your order be?
Well, each case is different. So if it would depend. So I wouldn't have, I don't have any part rules actually, because I feel that there are enough rules as it is between the commercial division rules and the CPLR and the local rules and all that. I've always felt there's enough rules. So I try to take things on a case-by-case basis. I'd like to keep remote oral argument on the motions. I think it's going really, really well, assuming people have the right computer equipment. And we've had a couple of, I guess, lagging has been a problem and feedback has been a problem. So, but usually I can walk the lawyers through technically what's going on so that ends up getting fixed while we're going through everything. So that's been great. So I'd like to keep it for motions. I'd also like to keep for bench trials, I think, and hearings. I don't know how, though, in a document intensive case, I know that the docu-share aspects of Teams can be a bit awkward. Some people have had great success with it. I know that I have not had occasion to use it. We just kind of go low tech and go right to the e-filing docket. So I would really, anyone who wants to appear remotely, it's fine with me. But if people don't want to appear remotely, if they feel they'll be prejudiced by that, obviously, once this pandemic is over, they're welcome to come in. I'm not gonna be a stickler about it. And I am concerned about the pro se litigant who may not be as well off. Right now, people, never overlook the value of the landline, because it's very clear, and people, I would have people call in if I find I need to have on the record oral argument. And I've always allowed remote appearances. I've never been one to not allow it. So, it would really have to be on a case-by-case basis. And I think I will definitely be, though, ordering remote depositions unless somebody has a real concern about, like, the lawyer being under the desk with cue cards or something like that. I'm not going to barring that, I don't see What?
I hadn't thought of that yet.
But barring
now I
that, I just don't see why we would go to the expense of flying everyone to where the witness is. I mean, you know, I have cases that are span the globe, and this way they can all be done and everyone can stay home.
All right. Well, thank you very much, Evan. What would you ask the courts to keep, drop, or change when we get to the post-COVID world, based on what you've learned about practicing in it?
On routine conferences in civil cases, I would urge the courts to use the technology that we're using right now, or some, analog to it, for the reasons that Sam Sakharov mentioned earlier, and that I've alluded to as well. So many of the conferences, I can't tell you how many conversations I've had with clients who said, "So you flew across the country, charged me for a round trip flight, perhaps slept overnight in a hotel because you got in late and the conference was the next morning, and you were in court for 13 minutes. Was that really necessary?" And my answer is, well, if the judge orders you to be there, you're there. Yes, it's necessary. And I think so many of those kinds of things can be done remotely. So I would urge courts, when appropriate, you're not assessing the credibility of witnesses, you're doing the business of the court to move cases along through the process, that can be done remotely. On the other end of the spectrum, although I think there are judges like Justice Crane who are having a positive experience with remote trials, and I'm very glad to hear that, I would prefer to try cases in person. And if I would prefer not for there to be an optionality to it when we're done with this plague, that courts will say, well, if you want to try it remotely, we'll do it remotely. If you want to try it in person, do it in person. I just think the difference, for a whole host of reasons, many of which we've spoken about in the past hour, are important enough that once the world comes back to something approximating normal, we should gather in courtrooms. It makes it much easier for the public to see what's going on, and that's an important part of our justice system. And the mechanics of examining witnesses, particularly cross-examining witnesses, which I'm sure is something that'll be covered by a later panel on trials. I would much prefer to cross-examine witnesses in public than over a screen. And so I would urge the courts not to maintain virtual trials as an option once we get past COVID.
And we've got a series of very interesting questions, and they really feature some common themes here. The first question relates, Evan, to something that you had mentioned earlier on, which is your ability to work with the younger lawyers in your firm. And the question is basically, has the move to remote hearings and remote procedures impacted the ability of younger lawyers to gain experience, including experience in open court, in order to develop their professional careers? And I would say their visibility with the courts. There is a huge and belated but welcome emphasis now on diversity in the courtroom, or what was the courtroom, in terms of lawyers who represent in every way their clients, who look like their clients, who look like America, being present and visible and active in the courtroom. How do we deal with that in a situation where, as Sam Sakharov said, the courtroom participants are now the Hollywood squares?
Mm-hmm. So in light of the time, I'll answer this very quickly. First, on the first part of your question, I don't think it's had a negative impact. I just finished a fact deposition program in a pretty large civil case where there were 24 depositions conducted. I took 2 of them, and all of the others were taken by younger lawyers in the firm. So that's I think just as it would have been if there were no pandemic. I probably would have taken the same 2 depositions and they all would have taken the other 22. So I think if you're committed to teaching the people with whom you work how to do what we do, the technology need not affect that and should not affect that. And you shouldn't allow the ease of getting on a screen and not having to travel to someplace to cause you to monopolize the FaceTime and monopolize the process. That's not in anyone's interest, and I think that shouldn't affect it, and it hasn't. I will say though, on your last point, Liz, where it has affected it, I was just thinking as you said it, you know, I mentioned that I've argued 2 federal appeals in the last couple of months, both remote. The courts have implemented rules, at least the 2 courts before whom I did those arguments, that the only people who show up on the screen, who are permitted to show up on the screen, are the lawyers who are actually speaking to the court, and of course the judges on the panel. And to your point about the players who are in the courtroom and you know, promoting diversity, et cetera, in both of those appeals, I of course had lawyers who were helping me on those appeals and helping me to get ready and make sure I don't say anything particularly stupid. And they were younger lawyers, lawyers of color, women, none of whom were seen by the panels in those arguments because the court rules were that only the lawyers speaking would be visible on the screen. So there is that aspect that the team is largely really invisible in some respects to the court, which was not the case before COVID. And I think that's very important. I mean, in many arguments, I've had young lawyers reach over, hand me notes and remind me of something or give me a point that I might make in rebuttal as in response to something that the lawyer on the other side said. And judges see that. I think it's important for the judges to know that these lawyers are doing their job and they're participating. And all of that was done by telephone texts on these arguments that I did recently. I was getting text messages from the other lawyers on the team, the same thing that they would have said to me by handing me a note or whispering to me in the courtroom. So I think there is that element of invisibility, which is quite unfortunate.
Thank you. There's a cluster of interesting questions, and we won't have time for them individually, but they I think converge on a single theme, and that is public versus private, both in terms of whether remote hearings and conferences are truly public, open to the public, whether they are private and confidential, and secondly, we think of courthouses, even though they're hard to get to sometimes, as a public resource, but the technology that we are all depending on to stay in court and come to court are private resources owned by corporations, managed by corporations. We're all on Zoom, et cetera. And you talk about whether or not someone can own or borrow a smartphone. Justice Crane, how should we strike the balance there? What can we do?
Well, that's a really good question. And, you know, I mean, any creative ideas are welcome. I actually thought, as we were talking about this earlier, we were touching on it earlier, that I think I recall, at least in 60 Center, that there are phone booths, right? Which I'm sure nobody uses anymore. And I'm wondering if they could be converted to some kind of you know, video conferencing station with a screen and a computer, and maybe ensure more public access that way. I also know that at least for depositions, that the court reporting outfits will supply a computer to whomever doesn't have it, because they want the business to be the court reporter. So, you know, this is definitely a concern. I know whenever anyone's asked, we will, as I said, we will stream the argument. I don't know if there could be closed circuit cameras maybe in the courtrooms. Any ideas are welcome.
Thank you. And Marie, you're on the front lines of this. Any specific prescriptions and concerns?
Yeah, we have a bit of a different concern because our clients are entitled to, you know, have a constitutional right to have a public trial, and that means all aspects of it. But in this new world, we also have to protect our clients' privacy, right? There's a difference between somebody coming into a courtroom where there's rules, you can't have your phone out, you can't record it, you can't take a picture, et cetera, versus, live streaming arraignments into everybody's home. And there's lots of sensitive information that comes out at arraignments, but also if someone is doing it from their home, we can't stop them from recording it on their phone. We can't stop people from taking pictures of our clients while they're, handcuffed and sitting in those booths. And then those things last forever. Once it's out there, we can't take it back. Whereas in a courtroom, a judge can control whether the media has access to come in and take a picture or not. And so we have really been struggling with the balance between like, how do we keep the public forum, especially for our clients' families, but without, jeopardizing their cases and really having sensitive information live forever, despite what happens with the case. It could be dismissed the next day, but that didn't stop somebody from coming in and taking a picture of our client during their arraignment.
Well, thank you very much. And thanks to each of you. I think our time is up and we have to move to the break of the next panel. This conversation, and obviously each of these panels is a full day conference at least. I will read the code again for those who didn't get it. It's CCJCC 21. Thank you all very much.